Good morning. I have no sound. I have no sound. Lauren, I'm in, but I cannot hear anything that's going on if the meeting is started.
Your call has been forwarded to an automated voice messaging.
Thank you. Period. I cannot tell a lie.
Over my head, I barely know how to work a cell phone. Mary, can you hear us?
Yes, I can hear you on your cell phone.
Mary,
I can hear you on your cell phone, Terry. I can hear you on your cell phone, Terry. Can you
Okay,
hear
yeah,
me?
well.
Okay. This is gonna be a
Okay.
little tricky.
Your voice is coming over, so. Mary.
Yeah,
Mute your computer so we can't hear you, and you can talk.
I'm impressed by your resume and your application, but also, as someone who works with probation chiefs.
Mary, you gotta mute again.
Doggone.
And what we've learned over the last several years is they do a really lousy job at it. That's why breathalyzers were not admissible for a number of years. That's why in the last several years, is they do a really lousy job at it. So that's why breathalyzers were not admissible for a number of
It's a 7-second delay, I think, Terry.
years. They do a really lousy job. So that's why I'm gonna suggest at this point that we turn that off.
It's a
There are some probation officers that do that. I first started practicing, that was commonplace. Probation officers would go to their homes, and, just not to catch them doing something. I first started practicing, that was, I know, yes. You don't have a job, probation officers go to their homes, just not to catch them, we're gonna shut that off. I first started practicing, that was, I know, yes. You don't have a job,
You can work on it after the hearing comes. They can work on it after the hearing, for the second hearing. It's a hearing on that hearing at this point. You can work on it after the second hearing.
Don't allow the camera.
Then you can take the video off.
Also, don't. Should I put allow or not?
Can't hear you.
Should I? It says allow to use your camera. Do I allow it?
Yeah.
I stopped it. Right here.
Now we can hear it.
Can we? Can't hear it.
No. Try to do that.
Yeah, I can't show up in celebration. Somebody come just.
That's, I think all of us.
Hi there.
Hi, Mary. Can you hear me?
Yes, I can.
All right. Thanks, Mary.
Can you hear them?
No, I could. They're fixing it. I think we're going to be okay.
Okay, what time are we going to start up again?
I think 12:05. But don't, like, pretty soon. Just sit tight.
Okay.
Because the band was actually 2 meters with the navigation programs of the planes. People don't understand. This one I did work on. This is what you should have. It's real. Thank you, Dennis.
Testing.
Eileen, can you hear me?
How are you, my friend? That's fancy. What's that?
I think I can hear you guys now.
In case there's still an issue.
You know what? It's the 5G rollout. It's today.
Oh, that must be why.
It is why. No, I'm serious.
Really?
It's, and that's why I said, this is nothing to do with this team. There is, I used to work in the wireless industry. That's what I.
That's right. Yeah.
This is what is happening. This is.
Do we know when we're going to start up again?
Hey, how are you? Yeah, I'm on the video. I'm on the video. I'm on now. It's working. Yeah, I didn't click on, but yeah, I'm good. I'm good. Did they finish the first hearing?
I believe so.
What'd you say, Mary?
Yes, they did, Chris. As far as I know.
Can you hear me? Hello? Testing 1, 2, 3.
Testing.
I can hear you. Can you hear me?
Can you hear us?
Yes.
Okay. We're testing the audio, Counselor.
All right. Terry, when is the next meeting starting up?
We have the assembly, Mary. We're waiting for the lieutenant governor.
Oh, okay.
Mary, you can hear me, correct?
I can hear you, Chris.
Now, though.
Yeah. Hey, Lisa. Come here for a second. It's going to start. You can't see it. What the hell? That come up. It's going to start in 1 minute. My question is my video. I can't see myself.
Yeah, you can right here.
Oh, put it on.
I can see you, Chris. I can see you, but I can't hear you now. You just unmuted, okay?
Okay, you good?
Yep.
Okay.
So they were gonna do the assembly now.
Yep.
Mhm. Mhm.
Hmm.
Mm.
We can't vote.
Yeah, I know that. There's no votes today.
Then why are we having an assembly?
I have no idea. Just the notaries.
Oh, okay.
Okay, assembly should start in about 1 minute. Yes.
All right, I call our assembly to order. And I am pleased to recognize Councilor Duff for our prayer and pledge today.
Thank you very much. Offer, a moment of silence for everyone in our court system who is working so diligently and hard during these challenges.
Okay, thank you. We are here to comply with the Massachusetts Constitution and the general laws relative to the tabulation and certification of votes cast in the January 11, 2022 special election to fill a vacancy in the Senate. I recognize Councilor Kennedy for a motion to record certification that Lydia Marie Edwards has been elected senator in the general court from the 1st Suffolk and Middlesex Senate District.
With congratulations to my friend Senator-elect to make that motion.
Second.
Second. There's a motion and a second. All in favor, say aye.
Aye.
Okay, and I believe she will be sworn in tomorrow at noon in the Senate chamber. The governor will be performing that task. So if you are in the building tomorrow, it would be Thursday tomorrow at noon in the Senate chamber. Okay. I now recognize Councilor Jubinville for a motion to record advice and consent for the financial warrant.
Second.
There's a motion and a second. All in favor, say aye.
Aye.
I recognize Councilor DiPaolo for a motion to record advice and consent for the pending list of notaries, public, and justices of the peace.
So moved.
There's a motion and a second. All in favor, say aye. We have two dates relative to the commutation hearings. Thomas E. Kuntz for commutation. His hearing will be chaired by Councilor Iannella and will be on Wednesday, January 26th at 10 a.m. Okay, and correct. William Allen's commutation hearing will be chaired by Councilor Jubinville and will be on Wednesday, February 2nd at 10 a.m. We have a new nomination. Sheila C. Harrington has been nominated to the position of Clerk Magistrate of the Gardner District Court, and Councilor Duff, you will be presiding over that hearing.
I will schedule February 9th at 10 a.m.
Okay, thank you. That's all that we have today. Yes.
One thing I forgot to say, on behalf of myself and the Governor's Council, congratulations to Representative Clay Cronin, who gave her farewell speech today. She and I started our careers together with Emerge, and she, as you probably all know, was our ambassador to Artie. So Godspeed to her and congratulations.
Thank you. It's an honor to have an ambassador, another ambassador from our Commonwealth, and we're pleased that Chair Cronin had the opportunity to share her message with her colleagues, and we look forward to congratulating her with you. Thank you. All right, is there any further business? Okay, that concludes our business today. Thank you.
Oh, look at me, I'm trying to put this in, it doesn't go. I'm getting it. Marilyn, continue.
Oh, thank
Called
you.
on you.
Thank you. Thank you, Counselor.
How many of the JNC members of the 21 that are appointed by the governor, how many were there at your hearing?
I believe there was one person or two people in the room and then 9 others by Zoom.
Okay. So I guess that, you know, my concern is 21 and only a few are there and all vote, and they don't see the nominee, they don't meet with the nominee. And it has nothing to do with you, but it's something that I talk about all the time, that it's not right. Because in past JNC that they were appointed, 21 were there and 21 voted. And that's what the state of Massachusetts should require. I mean, we're giving that, they're voting for a lifetime position, they're recommending, and then we vote. So they have more authority than we do, because they choose who they're going to have at a hearing and who they're going to recommend. And we don't know how many or any of that. We just have one person to vote on. And I think a lot of people don't know that. So thank you for letting me say that. So getting back to, I was impressed because, you gave a different idea about the challenges in the district court. And I like that. And talking about balancing the various and conflicting purposes of sentencing. And I'm the last one standing here always, so that's how it goes. But anyway,
I'm still here.
but instead of, well, someone has to chair it. Anyway, but so I asked you before we had the assembly that I was concerned about the Harvard Law School report and about the racial disparity in the Mass criminal system. And you have said in your questionnaire that it does exist. So I want you to talk about your feelings about sentencing, probation, and parole. And I liked how you said that a defendant should be given the details, the information about how the system works and probation and all of that. And, that's what I see in my 21 years, that there's some people that they're a defendant who do not have a lawyer and they don't understand the system. And unfortunately, justice isn't served for them. And so I love the idea that you do a lot of pro bono. So having said all of that, I want you to talk on that. The Harvard report, the mass sentencing guidelines. I don't know anyone that has ever said, no, I like it. And so I want to know what your position is and how you look at that. So yeah, you have the floor. You can talk about your math now. We're all great distance.
I think sort of a couple of key things that come to mind are when I think about sentencing, really balancing what the purposes of sentencing are. That public safety, when we think about public safety as a purpose of sentencing, we can't, because it is rehabilitation, but truly it's the public safety in the long run. And when thinking about the Harvard group, it's very clear we have disparities, racial disparities in our system, and sentencing guidelines just mentioned. I think the thing useful to me in those is that bias check. That as a decision maker in the system, whatever its role is, whether it's as a prosecutor asking for a sentence, a defense counsel asking for a different sentence, a probation officer recommending a sentence, a judge imposing a sentence, I think all of us, it's incumbent to really stop and look is impacting the decision making. And I think that in the sentencing guidelines, that bias check section can be very, and that's something that if I'm enough to be myself, people up here as well.
And the thing is that, that we see that, that I'm concerned about is erroneous convictions. And you've been involved in those, you've been involved in civil rights, employment. I love your background, I really do. So Tell me about some of the cases that you've had in trying to overturn those erroneous convictions.
Sure. So when I was in the Attorney General's office, I was one of a team of people who worked on cases brought under the erroneous conviction statute, which allowed people convicted of a felony sentenced to incarceration, served at least some portion of that, was overturned, allowed them to sue for civil damages. And I, a good number of those, and a lot of them I settled because it was that the person had in fact not committed. I did take one to trial twice, because we had a mistrial the first time, where it was someone who made for 4 counts of rape. And it was actually reasonably strong, even for the time. Standards when it was an application case. So I took that one to trial, and to trial first time and this verdict.
How about mandatory minimum sentencing?
I don't think mandatory minimums have necessarily served the purpose that I think have been intended to serve, which is perhaps deterrence and promoting statistically they and I think they do judgment to really truly tailor a sentence to the individual who I think they also have the potential to perpetuate racial disparities in our system.
And you know what I'm concerned about? We talk about people in drug addiction. We're not winning the war on drugs, that's for sure, for the last 40 years. That you've been very involved in substance abuse and mental health. Because we don't talk about that when you have someone that comes before you that has a mental issue. Tell us, you've been a member of a group. I want to know what you've done and what the goal is. And what do you see about people coming before you as a judge with it could be an alcohol problem or drugs or mental issues. So tell me how, as a judge, and tell me about how being a member, what you've learned.
So I've been a couple of years of Chief Justice Gantz spearheaded, Chief Justice Gantz chaired by Chief Justice Gantz and Chief Justice Gary. And was representatives from all the communities to look at issues of substance use and stacked with all of the aspects of our court system and how to make the system better. I mentioned when I was talking with Councilor Powell that really increasing the amount of full support was part of my role to represent the nation and to chair the on substance use and mental health. So I spent a lot of issuing things in regarding substance use and mental health. Still do that. Focusing is just incredible.
So looking at your 20-year career, what is your proudest pro bono? Because I'm happy about your pro bono work. What's your proudest pro bono case that you had, that you represented somewhere?
So I did pro bono work when I think when I was in private practice, this was to reading works where I represented who her time assaulted her, tried to actually she took out a restraining order against him, charged him, and 258A. I worked with the restraining order and the restraining order. It's just incredible to be able to work with someone that the system provides to help with safety and safety.
Good. You got a got a lot of letters for you, and I don't want to, dismiss them. They're very important. And where the chair went to eat with the rest of the council, we have a new chair. If you have permission, I'm not going to read them all, but I would like to tell you who the letter's from and some of the things that were said. One of them is retired Judge Peter Lauria, who was from my Watertown, so I know him very well. And he said a lot of good things about you. And he said you brought to the committee and the Superior Court and broad experience and substantial knowledge of the trial court system, and benefited from her years of experience handling civil matters as an assistant attorney general, criminal law, deputy legal counsel, and deputy commissioner. You have advised them, the commissioner of the Massachusetts Probation Service, and you have substantial trial experience as a lawyer in both the public and private sectors. I just can't hide how I feel, because a month ago we had someone 40 years old, and I was the only one that voted no, and he went to the district court. He had 2 jobs out of law school. One was he was one of 13 assistant solicitors in an office in a city hall, and the other one, he worked in the office of the sheriff. He had never, ever seen a criminal case, and he's gone to Worcester, where they have primarily criminal cases. So I can't tell you that this is the type of people that we should be having, people like you. We don't want someone to learn on the bench, and too many good people out there with 20, 30 years experience that are being bypassed. So now that I have vented, I just want to say these people are so credible that sent it. You had an attorney, Saracen, and he said how hardworking and smart and meticulous, and you're humble and warm and respectful, and everybody respects you. And then from Associate Justice Zookyung Chin from the appeals court, he talked about you working with you for 10 years in the Attorney General's office, and that you had complex cases and you were uniformly liked and respected through the Attorney General's office. And I have not an ounce of doubt that she will be courteous to all litigants, represented and unrepresented who appear before her. She is patient, sense of fairness. She knows the rule of law and she respects it. And said, I can't overstate my enthusiasm. So long and varied career in public service, making her one of those rare candidates with deep experience in both civil and criminal law. And also from Steve Van Dyke, who talked about working with you, and you always had creative solutions. And, and then there's one from from Justice Rosemary Conley of the Superior Court. And she talked about your experience and how fortunate that you are going to be on the bench, and also how you have volunteered for cases that would get you into a state or federal court, and also your probation department experience. And, I wish I could read them all. They're
all been entered into the record, as I stated earlier.
So I also wanted to talk about something that I have followed, and you have had profile cases, but the one case that I have followed through, and I'll tell you, that was the travesty of justice. And you were on the right side. But I can't believe that Dugan, about 2 years, what she did in that lab and hurt so many innocent people, and how many criminals are just no sentence. And I want you to, in your words, talk about that case and how it affects society, how it affects the judicial system, these people and their families that were affected, I don't even know, I could be corrected, 21,000 or whatever, I want you to tell us about that. But the thing is that, that it just seems so incredible that she's out walking now. I don't understand 2 years. So, you know, I'd like you to talk on that and tell us about that case and follow us. We'll follow you through it.
So I have sort of the aftermath of 2 last days. As probation counsel, one of the things I do is I oversee the records unit, which maintains the court activity record, which forms the basis of the criminal. And after the SJC vacated convictions of tens of thousands of defendants, we're seeing the updating of all of those records because all of those convictions were made. The other piece that I was involved in is there was a Supreme Court case the Supreme Court determined that if someone had been convicted and paid money as a result of that and they either were found not guilty after a new trial or the state decided not to prosecute them. The state then had to return any monies that it collected from that person as a result of the conviction. So as Councilor June talked about earlier, June often assess and fines. And so with the tens of thousands of as a result of those convictions. So I see and helped coordinate efforts to figure out what the process was for actually returning those monies to people. It's still ongoing. It's a very complicated process. Something that I spend a lot of.
Well, justice wasn't served, I don't think. Tell me now, what would you estimate the cost of what, you know, to make up for that injustice? What is it costing in dollars?
I can only speak to what the return of is, and I think it's still ongoing, but it is, say, in the millions of dollars. I don't know exactly how many, but it's of dollars, but I think tens of thousands of defendants and monthly amounts plus drug fee, analysis fees, and all sorts of other associated.
And you know, I didn't mean to make light of your applying for Superior Court twice and having 2 hearings before the JNC, but to me, it showed almost how ridiculous that the same members of the same Judicial Nominating Commission saw you and recommended you to be a judge in the Superior Court to the governor. He did appoint you. 3 years later, in 2019, you go before the same members of the Judicial Nominating Committee, and now they say you're not qualified. So when I said first you were qualified before you weren't, I didn't mean to be, make light of it, but that's why it's very difficult for me as a governor's counsel seeing this happen. And I just want to thank you for reapplying, because sometimes we have lawyers out there that won't apply again when they have applied, and then they see who got the position. And they know that it wasn't fair. And so I thank you really, because you're going to be great in the district court. And I have to say, it's obviously you love to write. And when I read your writing in your judicial questionnaire, it was outstanding. And so, you know, and I know the writing really is Superior Court, but I know in the district court you're still right, and I have faith that you'll give your decision why you will, won't you? You will say why you made that decision, right? I'm just so pleased that the governor has appointed you, and I think you belong in the Superior Court, but you know, and they said you're qualified, but you'll do wonderful in the district court. And you know, in my 21 years, the people that I know that are serving on the district court, like Judge Pomerol, they wouldn't take the SJC if it was given it to them. That's a people's court. They love that interaction. And I see that in you too, you know, so I'm really pleased with that. So, you know, I just think you've had all kinds of cases. And I like your philosophy about racial, you know, discrepancy. And all of those boards that you've served on have served you well to, you know, to help those people with mental issues and alcohol and drug addictions. Because we certainly haven't conquered that yet. But we need someone with your understanding. And I like your philosophy about sentencing and probation, and to explain to that person, because we see even people with commutations, they probably wouldn't have, they probably wouldn't be in the position now if they really understood the legal system and their rights, and that happens so often, and I see that. So I don't have a poker face. I'm going to be very pleased next Wednesday to vote on your appointment, and I just can't thank you enough for applying again. And it's very hard to be rejected, and you went through that twice, but you know, but third time is the charm, and you did it. So you have a lot of people that are supporting you and are very happy you're there, and everyone you work with can't talk more highly about you. So I'm very happy for you. So go to lunch, enjoy it, and thank you. And thank you for all the time at the diner, because that means a lot to me. And I have met with everyone because I want to know the whole person. I'm not voting for just someone on this paper. And I get to know you and your philosophy and what's your life experience. And, you know, I think you're 45. Yeah. And, you know, it is, you know, I like it in the 50s really, but the thing is you have life experience. And a lot of people don't have that, or being on these different committees that you have learned, and you know, so enough about that. I'm going to close now, and I thank you, council, for giving me the time. So congratulations.
Thank you very much, Attorney Ross. We spoke extensively. I'm sure we will be speaking again. I am not going to waste any time rehashing things that have already been said and spoken about. But thank you for your application. I will say that applying to be a judge, I know your husband is an attorney. It's I'm a big baseball fan, and it's like the baseball draft. You could be the best one year, and you might not be the next year. And that's just how it is. Could be the exact same people drafting you, but it's just who you're up against. So I know you know exactly what I'm saying. So anyway, thank you for your application. Thank you for your time. It's a pleasure to have you offering your service up to the Commonwealth. And with that, this meeting is adjourned.
by reading the letter from the governor dated January 5th. I am pleased to nominate Kristen A. Stones to the position of Associate Justice of the District Court. I submit this nomination for the advice and consent of the Executive Council pursuant to the Constitution. So welcome, everyone. We're going to start very quickly with, I know there's two witnesses here, Chief Dolly and Brendan Barnes. We're going to ask you to, whenever you're ready, Chief, you can stand up and give your spiel.
Thank you, Councilor Ferrara. Good afternoon to members of the Governor's Council. It's my privilege to testify this afternoon in support of Kristen Stone's nomination to be a district court judge. I've known Attorney Stone since 2003, when she first appeared before me in her role as a prosecutor in the Gardner District Court. Over numerous years, I presided over several jury trials and many motion hearings and arraignments in my courtroom in which she represented the Commonwealth. In addition, just over 4 years ago, I had the privilege of hiring her as an assistant deputy general counsel in the administrative office of the district court. At that time, she left her position as an assistant attorney general to join the administrative office. Since then, I've worked with her on a daily basis on a wide variety of legal issues that impact the district court. I can tell you from personal experience that Attorney Stone is highly intelligent, an excellent trial lawyer, has a very strong work ethic, and the highest level of integrity. She has strong trial and appellate experience, has worked in the district court and superior courts, and has expertise due to her background in dealing with mental health and substance use disorder related cases. In addition, she's highly respected for her competence and professionalism, but more than that, she is known to be kind, respectful, and decent to all. Her responsibility as Deputy General Counsel, in addition to her prior experience in the mental health field, as well as an assistant district attorney and assistant attorney general, have afforded her a wide-ranging experience on cases and types of matters that impact the district court. In her present position in the administrative office, she provides counsel and guidance on all legal matters and helps draft and develop district court judicial policies, especially on matters related to mental health and substance use disorders. In discharging these responsibilities, she has exercised exemplary judgment and discretion. In addition to her everyday role in the administrative office, she has served and been appointed on many committees, including the District Court Education Committee, Probation Committee, Domestic Violence and Harassment Prevention Committee, and most notably, she was appointed by the former Chief Justice of the Supreme Judicial Court, Ralph Gantz, to the Supreme Judicial Court Committee on Mental Health and Substance Use Disorders. In addition to these strong professional qualifications, I have observed Attorney Stone to be an exceptional person and friend. She's somebody deeply devoted to her husband, Chris, and their 3 very accomplished children. In sum, I would suggest that her career has been defined by exceptionally good judgment, balance, and fairness. She possesses, in my view, the exceptional qualities to serve in the district court. I support her nomination, respectfully ask you to confirm her nomination, and I thank you for allowing me the opportunity to speak on her behalf today.
Chief, always a pleasure. Appreciate your comments. Does anyone have any questions for the chief? With none?
I just want to say thank you, and what a tribute to this nominee to have you come.
Thank you.
Always good to see you.
Thank you.
Thanks very much, Chief. I know you're a busy man. Next, we have Brendan Barnes, First Assistant Clerk Magistrate of the Plymouth District Court. Welcome, Clerk Barnes.
Thank you. Good afternoon, everybody. Members of the Governor's Council, I want to thank you very much for your time and allowing me to speak on behalf of District Court nominee Kristen Stone. I, like Chief Dolan, went first in 2003. However, I was a lowly intern in the Plymouth DA's office. And as an intern, Kristen became my de facto supervisor, as I went to her for nearly every question a young lawyer could have. It's not often that you get to learn from someone with such prestigious clinical medical pedigree, the focus on the mind of people coupled with a sharply black. I absolutely took full advantage of Kristen's willingness to share her wisdom, as I found myself sitting in her office almost every day, discussing trial strategies, the practical realities of the legal system, and frankly, just life in general. It was the first time I had learned that a certain amount of humanity should be a part of the idea of what the justice system is. The part where the people that we're dealing with on a daily basis come as they are. They are indeed people just like you and I. As we left the office and pursued other career aspirations, Kristen and I stayed in contact. She continued to assist me, but I was struggling to wrap my head around various things as I was in private practice. As Kristen's breadth of knowledge grew, so did her ability to help me understand the law and how it should be applied. The pursuit culminated when we each joined the trial court in our respective roles that we hold today. Now, myself as a former ADA, former bar advocate, and now an assistant clerk, I can tell the members of this council that I've been in front of and around many honorable justices pretty much every waking day of my life for the past 17 some odd years. And I want to commend you, members of the committee here, of the council. It's crystal clear that you folks recognize by your outstanding nominations you made recently that district court justices need to be strong, intelligent, with great integrity, be fair and neutral, need to have social awareness, and be reasonable and make sound decisions. Personally, the most important for me is the ability to practice that manner, not to see court users simply as just docket numbers, but as human. Kristen has all those attributes in spades. I'm privileged to recommend her for this group. Thank you.
Thank you for coming very much. Anyone have anything for Councilor Jubenville?
Yes. Thank you. Let people know that Finance Assistant Clerk. He does it here and he does it right.
Good to know.
I'll second that too.
Excellent.
Thank you very much.
Well, congratulations, and thank you very much for coming up today.
When do I sign? Thank you.
You give up your chair for a few minutes for him, we'll get him to.
Great. Ms. Stone, if you'd like to introduce your company, I know we limited you to just one, but if you'd like to introduce your husband.
Thank you very much. This is my husband, Chris Stone. Also here in the room, Joe Jackson, who's the assistant administrator in the district.
Thank you for coming, Mr. Jackson. All right, well, we'll hear from you. Why do you think you should become a judge?
Brevity is the rule of the county.
I'll do my best. Good afternoon. I'd like to thank the council for the opportunity to appear before you today, and in particular, Councilor Ferrer for presiding over my hearing. I thank Governor Baker and Lieutenant Governor Polito for the privilege of being nominated to be an Associate Justice of the District Court, and I extend my gratitude to the JNC and the Joint Bar for supporting my nomination. I also want to express my appreciation to Bob Ross, Laura Gaines-Trino, Emily Gauthier, and Katie Babin for their professionalism and guidance through the application process. And I thank Chief Justice Dolly and First Assistant Clerk Magistrate Brendan Barton for their willingness to be here speaking on my behalf. I'm overwhelmed and humbled by the reality that I appear here before you today as a result of the ongoing example, mentorship, encouragement, and support of judges, clerks and court staff, colleagues past and present, members of the defense bar, and friends. I'm not exaggerating when I say it would be impossible for me to be sitting here today without the sacrifices, support, and contributions of my family. From 2 years of social work school and 4 years of law school, and years of working full-time as a prosecutor, my mother, my sisters, my parents-in-law, brothers-in-law, and their wives pitched in whenever asked and stood in my stead, care for and nurture my children, allowing me peace of mind for their safekeeping as I pursued my goals. Those children, now 28, 26, and 23, have blessed me with their constant and enthusiastic encouragement and are a source of immense pride. Of course, all has been made possible by the unwavering support and encouragement of my best friend since I was 14 years old, and the person responsible for everything good in my life, my husband, Chris. I grew up in Hanover, Massachusetts, the youngest of 4. I have 2 sisters and a brother. I attended the public schools there and graduated from Hanover High School along with my husband, as did our 3 children after we moved back there to raise them. My father worked as a salesman for both Canada Dry and Pepsi, and my mother worked at New England Telephone and Telegraph and then waitress. Eventually, my father opened his own vending business as a sole operator, and my mother handled the bookkeeping. As it was a small family-run business, my siblings and I contributed, and I worked there from middle school through college, filling snack and soda machines at the accounts and helping my mother in the office. Growing up, my house was filled with tension. Father was what was described colloquially as a functioning alcoholic, whose temper often got the best of him. But he was not without good qualities. He was smart, enjoyed athletics, had a crazy sense of humor, and he was had compassion for the underdog. As I grew up, I would hear stories about his upbringing as one of 10 children and the significant domestic situations that he faced. It gave me insight into what perhaps accounted for his behavior. As I matured, I reflected on the challenges he had faced and gained an appreciation for his successes in spite of them. Mother was the heart of the house and loved by all for her kindness. Her hard work and desire to provide for her family were the reason the family business survived. Her encouragement and love are why I thrived. I was the first in my family to graduate from college. My only regret as I sit here today is that she's not alive to be by my side as she was for every step of my journey. My path to the law was a bit of an evolution. As an undergraduate, I was drawn to the emerging field of behavioral analysis as it related to violent offenders, and as a result, I majored in psychology. Eventually, that interest led me to pursue a master's degree in social work with the goal of working in a forensic setting. One of my classes was on mental health and the law, a captivating course, and turned out to be the first seed planted in what ultimately became my desire to go to law school. After receiving my master's in social work, I worked at Bridgewater State Hospital, conducting individual, group, and substance abuse therapy with involuntarily committed patients. Because each of their commitments was connected, at least at some point, to a criminal matter, my exposure to and interest in the law grew, which motivated me to apply to law school. I began my first year of law school with a 5-year-old, a 3-year-old, and an 11-month-old at home. Upon graduating from law school, I began my career as an assistant district attorney in Plymouth County, where I prosecuted cases for 11 years in the district and superior courts. In 2015, I joined the Attorney General's office, where I continued prosecuting cases as an assistant attorney general in white collar and public integrity. For the last 4.5 years, I've acted as deputy general counsel in the administrative office of the district court, where I advise on legal and policy matters relevant to the district court. Thank Chief Justice Dolly for his example and mentorship from the beginning of my legal career in 2003 to my current role in the administrative office, where I witnessed the myriad ways that the district court, with the dedication of its judges and court staff, positively impact the community today. I'm confident that at this time, my professional and life experiences have equipped me with the judgment, knowledge, perspective, and temperament to effectively take on this extraordinary responsibility. That I be confirmed and be afforded the privilege of serving as a judge of the district court, I will administer justice fairly, with integrity and compassion for the safety and benefit of the community. Thank you, and I welcome any questions you may have.
Thank you. I have to say you have an incredible, diverse resume, going back to being an EMT to working the blood bank to working at Amigo, where I have a friend whose son is institutionalized there, and what a great program that is. So, very, very impressive. Harvard, he must be a little bit smart. Very impressive. We're going to start with anyone here on behalf of the nominee? Anyone else? Anyone not in favor of the nominee? It's a good thing the state house is closed. Terry Kennedy said. But we're going to start with trying the technology again. Councilor Hurley, can you hear us?
I can hear you loud and clear. Thank you.
I can hear you loud and clear. So why don't we start with you?
Sounds good. Sarah, we had a extensive conversation, and as Councilor Farrar said, you have an extensive resume. I was very impressed with the number of panels and writings that you did during your career. My question to you is, which of your work experiences did you like the best? He's sitting right behind you.
So I think I'll be able to accomplish.
You can take your mask off.
Thank you.
Oh yeah, I meant to tell you that. Whatever you're comfortable with.
I think I can accomplish respecting the person behind me in 2 ways. The district court, working in the district court, there's really no substitute for that. it's where I cut my teeth. It's where I spent the first 3 to 4 years of my sort of indoctrination into the criminal world. And that I would have to say, that time there, being able to be in front of judges like Chief Justice Dolly to show you what good quality judges are by example and leadership. I would have to say, I only got to sort of come back to that in my more current role and get a slightly different perspective of it. And before that, I was as a prosecutor being in front of a judge. The last 4.5 years has given me insight in the role of a judge day to day that I see from, behind the curtain, if you will, the real logistical and practical issues that come up and the dedication and devotion to judges to problem solvers.
Thank you. Which of your experiences in terms of where you've worked do you feel has helped you the most to become a district court judge?
I think it would be my experiences before ever coming to the law. And I'm sorry, if you're talking professionally, is it?
Yes.
Because, personally, I think it was raised in my family, but professionally, I would say my experiences before ever coming to the law, it's very challenging to do therapy with people at Bridgewater State Hospital, knowing the gravity of the offenses that some of them had committed, but also being true to the idea and believing in the potential for them to gain insight and improve and contribute to their ongoing mental health wellness.
All right, thank you. Obviously, I don't have to talk about the scourge of drugs with you. I think you've got a good background to be prepared for that. And usually the dual diagnosis of mental illness with self-medication in terms of drugs and how destructive that can be to somebody's life. What do you think you're going to enjoy the most about being a district court judge?
Just having the opportunity and the privilege to do whatever I can to positively impact the people that prepare before me, and by extension, the community.
Okay, thank you. I also checked you out, not with your boss, but with some of the folks that I knew from when I was in the district court. And they said that you are the real deal. You're a nice person who does a good job, very conscientious, knows the law. And those are all the kinds of things that you're going to need in the district court. In terms of the camaraderie, I think you've probably observed some of that in terms of different judges helping out new judges, and you'll be a beneficiary of that as well. So I wish you the best of luck. My only advice to you is to get a robe before you start. Somebody who is now on the appeals court actually showed up in my court without a robe her first day. And luckily I had 2 robes, one from my parents and one from the Bar Association. So I think you're going to do a great job, and I will be voting for you next week. Thank you.
Thank you.
Thanks, Council Hurley. Council Kennedy.
I received a lot of phone calls about them from various people. I think the person who the strongest was Judge Horrigan, Dan Horrigan. From the DA's office. And one of the things that he raised with me is that was concerned that I'd have concerns that you were coming out of the Plymouth DA's office. Because as you know, they tend to be a little tougher than some of the other DA's office. Would you agree with that?
I would.
Okay. And he knows that's always a concern of mine because, and I've known him since he was a young intern in the Malden District Court many years ago. Somebody I respect a lot. Which brings me to a question, like your background is mostly in terms of the courts as a prosecutor. Either in the DA's office or the Attorney General's office. You're not gonna be a prosecutor anymore. You know, you've been working in the trial court. But you gotta change hats, so to speak. How are you gonna do that?
First and foremost, I think just in recognition that my role is different, that I'm not in sense anymore. I'm painfully aware of the burden that rests on the prosecution to prove a case.
Right.
And I would, in all instances, hold them to that burden. I understand that it's an adversarial system, but there are two parties that are appearing before you in matters, and they really deserve justice and a decision that's based on law and handed out justly and with passion.
You would agree with me that there is, my friend Councilor Judah always points out, there are judges on the bench that tend to be looked upon as judges that either favor a defendant more often than not, or favor the Commonwealth more often. Agree with that?
That there are judges that do that?
Yeah.
Yeah, I guess there was.
Some, you know, you walk into some judges that are Commonwealth judges, right? They tend to always go with what the DA wants, right?
More often than not.
Okay. What kind of judge are you gonna be?
Straight down the middle. If there's, I'm gonna hold people to their proof. I am going to evaluate a case on its merits and the interview before me on merits.
I asked you a lot of questions on the phone. Kind of drilled you a little bit on this issue, right? Let's start with 58As. Too many 58As filed in the Commonwealth of Massachusetts.
I would say yes.
And what happens when somebody files, and I asked you these questions, right? What happens when somebody files a 58A motion? DA goes, right, walking in court, it's a domestic violence case. Not that every domestic violence case isn't serious, they are. But there are different levels of seriousness in terms of the situation. We got somebody with no record, an accusation of domestic violence, no history there, who's got arrested the night before. He's before you and Judge Stone, and he, the DA stands up, says, Judge, we're filing for a 58A motion. We want a hearing in 3 days. What happens?
Typically happens, or what would I do?
Well, let's start with what happens generally.
What happens generally is that that's granted and the hearing gets put on for previously.
Person put in a cage for 3 days, right? Somebody with no record, somebody with no history at all, somebody who wouldn't go to jail if he pled guilty, right? Most likely on the facts I described, right? And there he is, all of a sudden, or she, sitting in a jail cell for 3 days, probably stunned by it, right? Why should that happen?
Again, judging every case on its merits, I think that there are circumstances where if that case factually was not complex and the level of evidence that was anticipated to be presented at the 58A, I would schedule it for that day.
Okay, so you wouldn't hold.
I wouldn't hold it.
DA says, we need 3 days.
That's the basis for that. I'd hear from both parties.
Okay, so the victim's not available, she's at work.
Well, I mean, again, judging things on the merit, hearsay is admissible. If the victim was not available and this was an appropriate circumstance where we could have that hearing, they're on all kinds of documents or other tough, complex cases.
It's gotta go over for 3 days for one reason or another. Are you gonna hold the person?
I think I have to.
I disagree with that. I don't think you have to. I think you have other alternatives available to you. You can put a stay away with a GPS and you can have a hearing in 3 days. Because most times what happens, I'm in court every day, I sit in council, these things. You show up 3 days later and the DA stands here and says, okay, here's the conditions we want, like the conditions of release. Can you agree to these? They don't even do it here. But they hold people for 3 days. And it's become almost a cavalier attitude about it, as though so what, someone's going to jail for 3 days. Going to jail is a big deal. Especially for somebody who's never been there. They can lose their job. They can, their reputation, everything, you know? As a mental health professional, I'm sure you would realize that that could be pretty damaging to the mental health as well, at least during that period. I don't think you have to hold. Why do you think you do?
I think, based on my understanding of the law and the case law, that once you allow the continuance, that the individual, after finding probable cause, that they committed the crime, just probable cause, that you have to.
All right, how about pretrial conditions? Are they overused? Give me everything I asked you on the phone, guys.
Yes.
I gave you the questions, I think I gave you the answers, but go ahead.
If they are overused.
Okay, so what's Judge Stone gonna do when the DA says, we want this person on a GPS and a scram, in the middle of a pandemic, when they're gonna be sitting on that for probably the next 2 years before their case gets reached? For some little way, that's 3 years.
I think you have to look at what's being asked with the critical eye. Is it really going to promote something relative to the case, the charges, the offense, the conduct that's before you? I think you should just.
Okay, I gave you the fact pattern already. They want conditions on this domestic violence case. This indication was alcohol involved that night. That's what you got. You put them on the screen. I gave you the facts. That's what the DA is gonna give you.
If there's a reasonable basis to annex any of those conditions to the charges, then I think I would at least consider opposing.
Yeah, do you think scrams were a good tool to use in the criminal justice system? I think they're junk. I had a case down in Quincy a number of years ago, where the person was on pretrial conditions of release out of the Woburn District Court. And he flunked a scram early in the morning. Within an hour, the police were there. We got a warrant on him, and the police were there. The police looked at him and they had a high meeting, whatever the scram was, I don't remember what it was. The police brought him to the Braintree Police Station, and they looked at the guy and says, he hasn't been drinking. They gave him a breathalyzer. It was 0. No alcohol within an hour. He was kept in custody because of the warrant, the non-bailable warrant. He was transported up to Woburn in the afternoon. Judge looked at the scram, judge looked at the breathalyzer. Okay, let him out. Missed the day's pay. Just work. Put in handcuffs. With a cell, transport. We have breathalyzers in Massachusetts that my friend Judge Brennan has spent a lot of time talking about, okay, as you know. And one of the things that we've learned during the 6 years of litigation that's been going on with those machines, I'm talking about the ones that are certified by the Office of Alcohol Testing, is that they do a really lousy job of what they're doing. That certainly seems to be the case. And those are machines that are certified, they're calibrated, they're tested. They're brought in every year to the Office of Alcohol Testing for certification. Who certifies the scrams? Nobody knows. That's one of the problems. Who calibrates the scrams? Nobody knows. Nobody can answer that question. I've asked it 1,000 times. And here we have a statute that talks about these other breathalyzers that they have rigorous testing on, that there's all kinds of problems with. They've barely been able to use them for the last 6 years, as you know, because of those problems. And yet we're putting in people in jail for failing a scram that has no standards in place for it. None. You're gonna put somebody in jail for flunking a square? Either on probation or pretrial conditions?
Yeah, I would like to hear the circumstances of.
He's out on pretrial conditions, he's got a scram, he blows into it 4 times a day. Okay? Or misses a scram. I have a lot of clients that seem to miss them at 10 o'clock at night because they're my age and they go to sleep at 7 and they sleep through it.
Those would be the kind of details that I would try to elicit. What is the
Okay,
basis?
but this person's guilty of it. They flunked the scram. They blew into it, they drank. Okay? You issued an order, stay alcohol free as a pretrial condition and take a scram 4 times a day. They flunked one. What are you gonna do? These aren't hard questions. You're gonna be asked to rule on these very soon. I guarantee you, within 6 weeks, after you're approved, you get approved. 6 weeks from now, I'm voting for you already, so don't worry about that. 6 weeks from now, you're gonna be making these decisions. You're gonna make these calls. You're gonna be out there on your own after you go through the trial court training. 6, 8 weeks from now, you'll be sitting in a probation surrender or an arraignment session. They're gonna be bringing that exact scenario before you. What are you gonna do?
I want all the information.
I just gave it all to you.
Possibly have.
Guys on a domestic, no record, alcohol involved, you wanted a scrim or some other judge wanted a scrim, he drank.
No, I wouldn't say that. I would absolutely.
Okay, so you're not provoking. What about 3 weeks later, you're back in probation and counsel for he said, Judge, he did it again. He drank. Nothing else, no other violations. What are you gonna do?
I think I'm going to consider whether there's something else that might be added to probation that perhaps can identify or address the drinking. But again, relapse is part of recovery. If this is somebody that has a substance use disorder or is struggling with substances, then relapse is part of. So I don't think the answer or the help isn't going to be to lock them up. Okay. Public safety always has to be a consideration, but I don't think.
This isn't a driving under case. There's no record of any drinking or driving.
No, I would not.
And he's no indication that he's violated the stay away order from the victim. At what point are you gonna lock him up if he keeps running from the squares?
At some point, there could be a threshold that he's not able to comply with the orders of the court.
Oh, you take him off the scram. The garbage.
Yes.
Then you don't have to deal with that issue. They're not accurate. They don't work right. People get violated for no reason. Okay, another scenario dealing with the scram. Bunch of scram, pretrial conditions. You're down sitting in Brockton Court. You started there, right? Okay, you're in Brockton Court. We're going back in time. You're in front of Judge Nagel. And you're sitting there, or you're in his court. You're sitting in a session. They bring, the DA comes into you and says, "Oh, probation told us this guy flunked the scram. We want a warrant." What are you gonna do?
Going to ask first and foremost if he's represented, reach out, find out whether.
Okay, that's good. That's a good answer. Because defense counsel is entitled to know when the case is brought forward. Happens to me all over the state. I never get informed. I find out when I show my client there's a warrant or he's taken into custody. Nobody calls me either before or after the warrant. And sometimes there's a very legitimate reason for it. And most judges, I've been screaming about this for the last 3 or 4 years, that defense counsel is entitled to know this. Under what circumstances would you issue a warrant? All right, now they can't get a hold of me. I'm in a movement. Okay? I'm on vacation. There's a flunk scram, they're looking for a warrant, they can't get a hold of me, what are you gonna do?
Would entertain issuing a warrant on public safety or a victim's safety.
You have the facts. I gave you the facts. What are you gonna do with that fact now? I'm gonna make a suggestion. How about a summons? How about mailing the defendant a summons and giving me notice of it? There's no reason to lock someone up just because of a violation of a pretrial condition unless it's a significant violation, like a new charge or something like that. A serious public safety issue. How about you issue a summons, give me notice, and I can come in and tell you my client was in the hospital, whatever it was, right? I'm not a fan of pretrial conditions. Of a presumption of innocence. A lot of times the conditions that we put on people are more severe than they are when they're put on probation. And a lot of times people on probation, they're not on scrams. A lot of times people are on probation, they're on probation, they're not on GPSs. Under what circumstances, as a pretrial condition, would you order a GPS?
Only when there's clearly defined areas that I want. Primarily in my.
All right, I'm on probation in Brockton, the victim lives in Easton. You ordered me to stay out of Easton, right? And you put me on GPS to keep me out of there, right?
Away from the victims.
Yeah, that area,
Yeah,
right, okay. Now I wanna go to Florida. When I go to Florida, victim's not there. I'm going to Disney World.
Give you probation of the court.
Why do I have to notify probation?
That's, standard conditions of probation that are.
No, there's no standards and conditions of pretrial probation. There are whatever conditions you, the judge, set. And it happens all the time where judges issue, put people on GPSs and do not order. You gotta remain in the Commonwealth of Massachusetts. But you know who has that condition all the time? Probation. Without a judge's knowledge, do you know why they do that? It's one of my pet peeves. I deal with it all the time. They do it because they don't want the equipment out of state. They're worried about losing their equipment. It's expensive. You haven't ordered me to stay in the Commonwealth of Massachusetts. Probation comes before you. Judge, look, he's in Florida. He's got our equipment. We want a warrant. You can issue a warrant?
I don't think that's a basis for.
They do it all the time. It happens every day. People have warrants out for their arrest for leaving the state when nobody ordered them to stay here. I understand when you're on probation, that's a standard condition. Usually, in most cases, I'll ask that that not be a condition, depending on the circumstances. Because as a general rule, there's no reason to have people remain in the Commonwealth of Massachusetts. And it's frankly a pain in the butt to be going in either on pretrial conditions or post-trial probations, getting permission to travel out. I think I spend more time going in, especially since the pandemic, with everybody out in conditions for extended periods of time, getting them permission to travel for work, for vacation, whatever. I'm always running into one court or other, going in front of a judge, which are allowed. They're allowed, but I don't see why I have to do it. I don't see why the defendant has to do it. Do you think of any reason why they would have to? Okay. So a probation officer comes in front of Judge Stone and says, John Smith left the state. He's got our equipment. We want a warrant. What are you gonna do?
Say that judge ordered him not to leave.
You gonna say what?
I'm going to ask any judge order this person not to leave the Commonwealth.
Well, they're gonna show you a probation contract that says that. But the person filling that out is the probation office. You follow me? That's what happens.
And I would say no, if it was not court ordered.
They treat it like it's a standard, like they're on probation, it's a standard condition, and they have the same, sign the same contract you do as though you're on probation. Would nobody order that? great resume. I think you're gonna be a good judge because you listen and think, what you did here. And I hope you do that when you're on the bench. Be down the Cape, rumor has it. Region 1,
Yes.
that's probably one of the best regions in the state in terms of the judges down there, very collegial. Enjoy it a lot. I'm all set, Mr. Chairman. Thank you.
Thank you. Also, the best region to be the governor's council too, I'm just saying. Councilor Ionella, can you hear us?
Yes, can you hear me?
I can. Would you like to go next, sir?
Yes, just a few questions. First of all, it's good to see the Chief Justice Dolly here. I have a lot of respect for him, and I know you worked with him, and I know he's a big supporter of yours. I know Councilor Kennedy asked a lot of questions that I was going to ask, but just a couple. Now you're sworn in, let me back it up. You've been confirmed by the council, you're sworn in, now you're a judge. And now it's February 20th. And defense attorney, prosecutor, whoever comes before you and says, you know what, I don't feel comfortable going to trial next week because of COVID. Can we continue this case for another, I don't know, 2-3 months, assuming the district court is back to having trials? What is your position going to be in that case if the district court, Dolly says, hey, yep, trials are beginning, February 1st, and now February 15th, the lawyer comes in, hey, I don't feel comfortable. What are you going to do?
I think that's a reasonable basis to ask for continuance. I'm sorry, you're still, see your mouth still moving, but I can't.
Can you hear me?
I can. I think there was just a delay. I didn't want to talk over you. I think your mouth is still moving.
Okay.
I think that's a reasonable basis to ask for a continuance and for a continuance to be granted.
Well, that's good. Thank you. My last question is, I'm a believer in rehabilitation, if possible, and under the right circumstances, as opposed to incarceration. What's your view?
I think that incarceration is something that should never be done lightly, and that if at all possible, taking into account public safety concerns, my preference would be to make use of as many tools available to the court system to rehabilitate somebody so that we don't see that person again.
Well, thank you very much, and best of luck. Thank you.
Thank you.
Thank you, Councilor Ionella. Councilor Jumonville.
Just to get back to the swearing machine. There's some problem.
There's no problem. Go ahead. You have the floor, sir.
Just to get back to the swearing machine. It's been my experience that the swearing machine prints out document saying that the person has failed. That form is that's from the probation officer, usually hand that to the judge. Violation here. Unless it's changed recently, whoever get one of these forms, I suggest you read it from top to bottom. I don't think you'll find the word ethanol or alcohol on that entire form. So think of it as a machine that measures alcohol intake. And it probably is, but my point is that evidence at a hearing, a document that doesn't say anything about alcohol or ethanol alcohol. One judge said, being district and the probation officer, this form doesn't say anything about alcohol or ethanol. Your duty is to prove to me that he's failed because of alcohol. This doesn't do it. He didn't find some violation, but I don't think the form has changed at all. The other thing is, if you Google breathalyzer, these swearing machines, you'll find a lot of studies done on not false positives, they're real positive, but they're very sensitive to ethanol alcohol. And bodies produce that There are certain things that we eat. Heavy dough products like bagels and pizza dough and that kind of stuff. As we digest it, produce ethanol alcohol. And it can give a reading to these machines. And some of the violations are like 1.01. The lowest you can have, set the machine off. We've been arrested, held for a weekend, brought to court on Monday. Based upon a very tiny reading of things. And there are other things that can set that off, like toothpaste and mouthwash. So my point is to be a little cautious of the machines. And sometimes they put machines on people who have alcohol issues that are not getting any treatment, falling into this machine. So they might relapse on the machine. But if they haven't left their house, didn't go out and commit another crime, then would consider that, say, well, do I need to put him in jail because of that? He hasn't left his house, he didn't commit another crime. He's not getting any help with the alcohol, but yet we're asking him to pass all these tests. And if giving up alcohol was simply accomplished by giving somebody a spraying machine, geez, they'd be handing those out at AA meetings left and right. They don't have any effect. Fear from a court or a judge is not addictions. Addictions always win over. Why people that addicted to opiates can't get off of them. Judge's order of free. That's a big order. It's almost impossible. We expect them to do it. Come get them put in jail. So I'm getting out here. But I have known you time you were in the DA's office down there. Action, and I must say I was sitting here thinking that I've never had one issue with you in any way. Just to deal with, just the people, courthouse defendants. You didn't take pleasure in sending somebody off to jail. Follow the Paul Donnelly schooling of people. He was like two. And so I don't have any more questions.
Thank you, Council Jungle. Council DePaul.
Thank you. Good afternoon. So, we heard discussion about pretrial conditions and a little bit about conditions of release as well. Something I hear iterated in various places is that we should consider in the Commonwealth whether we're revoking probation for technical violations too frequently. What do you think about that? Have you heard that criticism, or strike that? Have you heard that suggestion? Do you think it's true?
I think there is another truth to that, yes.
What kind of, when you consider what truth might be behind that, what kind of technical violations or what kind of situations come to mind?
Simply requirements that someone maybe check in once a week or twice a week by phone call. Or something, expectation that something happens a certain times of the week. Payment of monies or things of that nature.
So something's done a couple hours late, a check-in or
Correct.
something. Okay.
Correct.
And what about some of the discussion around GPS devices? Meaning the example of leaving state. Like this happens, as was discussed, right? So someone leaves the state and a warrant is issued.
Sorry. Considering that, what is the?
Let me back up. So when you're considering conditions of release, I think what I heard earlier was that for a GPS, you'd consider that an appropriate condition if and when there was a specific zone that was relative to a protected victim, or
Correct.
class of victims. So in other circumstances, GPS wouldn't be necessary or warranted.
Correct.
When talking about how to exercise your discretion as a judge, you wrote that you'd want to create a just sentence that balances the need for public safety, victims' rights, deterrence, and an opportunity for rehabilitation. So how does deterrence figure into that formula when you're considering a sentence in a particular case? What's the consideration given to deterrence in determining that sentence?
Well, I think the balance has to be for, some accountability for the conduct that has taken place under the umbrella of public safety. Particular person in the community or community at large. And that rehabilitation should be the goal to give someone an opportunity for a second chance for growth. Those, I think, are the primary goals. Deterrence, to me, deterrence, I think, encompasses some of the things you could do in probation that will help deter future conduct that will bring you before the court. So deterrence, to me, isn't necessarily put them in jail. Deterrence is, what can we do to not see them again? Deterrence is about future recidivism, if you will. And so whatever might mitigate or address that should be the goal.
So reducing recidivism at the end of the day, one could argue, is the point of the system. Whereas the point of having penalties, that we're doing something that will keep someone from having.
I'm sorry.
That reducing recidivism is a primary goal of the system.
It is, I would say public safety is the primary goal. I think people have a hard time saying almost anything in their life if they don't first feel safe. So public safety, I think, is the primary goal, but I would say that rehabilitation can accomplish that as well. Because if you're rehabilitating somebody, then you're by implication, it's also going to increase public safety.
Is incarceration a safe setting for people? Does incarceration encourage rehabilitation?
I think in some circumstances, again, I think there's very much a focus these days in the houses of correction to maximize the time that people spend there to involve and get them sort of a jump start in a lot of programs that hopefully they can take even to prepare them better for when they.
And I very much appreciate your background, particularly before your legal career. You have perspective on these issues that we're talking about, it seems to me. I've heard that today, right?
Yes.
I heard today concurrence that some DA offices can be tougher than others. Tougher was the word that was used. What would it look like for a DA's office to be tougher than another DA's? What kinds of things would I see that would make me think that?
I think it essentially just a general policy that there's not a lot of fee negotiations, that the Commonwealth has a certain position on a case. So they may be sort of more wedded to that than in other office where they're more agreeable perhaps to amending or changing.
Sorry. Would it be possible that some DA's offices or perhaps some ADAs in their discretion would be more aggressive with initial charges than others?
Yes, I think that would also be encompassed by same philosophy, yes.
And in all likelihood, some DA offices are more aggressive there than others. Are you familiar with the Harvard study on racial disparities in sentencing?
Yes.
So the two primary places where the study suggests that things are happening, if we're trying to pinpoint on the causal chain, in the judicial system, you could go to social issues, go way back. Initial charging phase, where Black and Latino defendants are twice as likely to be put in superior court when there's concurrent jurisdiction between superior and district, obviously exposing them to increased sentences. And then related to that, the facing of, in some cases, mandatory minimums, but at the very least, charges that expose them to more potential consequence, right? Like larger potential sentences. So if I'm connecting the dots, then the DA's office that is aggressively charging in the initial phase, it would seem to me has to think about what the achieved social goal is of doing that. Do you think that there are negative consequences, perhaps unintended, behind DA's offices that are aggressive in their initial charge phase compared to other DA's offices?
Well, if there's a disparate effect of that, then yes, I mean, if they're applying that across the board in how they approach cases, I think there's a twofold, that's certainly gonna capture everybody in that particular county.
Sure.
And so, yes, all of those people that happen to live or commit crime in that county are going to have that be a consequence. And certainly if that is being particularly damaging to those who are Black or Latinx, then yes, that is going to be something that will have downstream and longer consequences, yes.
But beyond even race, because race is kind of tied up in all the background issues. I mean, social status and the community where you're raised and these kinds of things impact the path someone's on, right? So how about criminal history? How does that factor into your thinking as a judge, especially around sentences?
So I think that the board formation record, criminal history, I would look at with a more critical eye now than perhaps I might have done as a prosecutor, based on a lot of the studies and the results that we're learning, that I would probably look at certain offenses and kind of try to look beyond the offense as it's just on the paper into the possibility of where this person committed this offense, whether they were more likely to have a police-initiated interaction for that offense,
right,
or whether it was something that seemed to indicate it would probably be more of a reactive interaction with the police, maybe a citizen call or a victim call, bringing the police to interact with this person, as opposed to something that might more typically have happened with a police-initiated interaction, drugs, guns, stops, those kind of things, and probably, again, critically view those and give them, maybe weight them differently.
So, because it's not merely race that's at play in this kind of stuff, right? So it's about class and it's about socioeconomic status, right? So the two examples that were brought up, or two examples that are brought up frequently here, is that, again, in my neighborhoods in Worcester, Clark University and Holy Cross kids are smoking pot just as much as the kids in Maine South. And we know what's happened over the last 30 years. We're putting that behind us. But even around addiction, I interact with the police because I'm robbing cars or houses in my neighborhood. But I live in an affluent community from an affluent family, and I'm stealing from my parents, my friends who aren't reporting it to the police. So I have a hard time understanding why the criminal record matters, given that the criminal record indicates that the individual has served their time or faced consequence for the behavior that we're seeing on the record. What do you think about that?
I mean, I think I'm very much.
And let me just say, I'm sorry to interrupt you, but so I have one defendant who has a criminal record that includes whatever it is, theft or something, to stick on an example. I have one that has nothing. The one that has nothing, I don't know what that tells me, other than they've had limited interaction with law enforcement. Or that but the one who has a couple, again, all I know is that their behavior happened to intersect with law enforcement. And again, they face consequences. So against that backdrop, why is criminal record relevant in your sentencing? Or how would you formulate the way criminal records relevant in your sentencing?
Well, one of the things that I observed in my own practice is that, the judge would elicit information from the defense attorney. Do you know anything about this? Can you explain any of this to me? And I think information that you can elicit, the more information you can elicit about what is in front of you on paper, the better you can determine what worked before, what didn't work before. What were the circumstances of these? Do you know anything about the conduct here that's reflected? To just give you a better picture.
I think that's great. As a judge, would you take those proactive steps? I mean, would you confer with defense counsel? Does this person have childhood trauma that we don't know about that's not coming up, et cetera, et cetera?
Absolutely. If counsel was willing to share that information with me, I think more information is better.
What do you know about brain development as it relates to the arbitrary age where we've set legal minority?
Well, I know that the law is recognizing that juvenile brain development is an evolving thing, that, recent case law, Atty, that was the case with the contempt hearing, specifically says that the court should take into consideration someone's age when sentencing.
I'm sorry to interrupt you. Diachenko, the SJC says that we should take into account the actual brain science, which, as it exists, clearly indicates that what we consider adulthood around impulse control, executive functioning, that it's not done at 18, especially not in men, and it's exacerbated and delayed years further for someone who's experienced childhood trauma. So I'm waiting to see how this. This should be playing out in our court system, I would imagine. If we're being told to consider this on the one hand, but we're playing by the rules that exist, I guess by tradition, right? Because we have to draw a line somewhere. I mean, as a judge, is this something on your mind when you're seeing defendants before you?
Absolutely. My position isn't that, well, geez, they're 18, and so snap, they don't fall within that purview anymore.
Right.
It's they're 18, and I understand that they're still, their brains are still forming and developing. They're still gonna probably have a lack of insight or judgment in some of their behavior, and that's absolutely an appropriate consideration for me in all aspects of addressing why that person is in front of me. And I would just, mention Diachenko, but I think even more recently, we're continuing the courts and law are continuing to recognize the appropriate place for that in not only sentencing, but in section 35s. Matter of a minor, talk about how, hey, when you hear a section 35 that involves a person that's young, you should make sure that you're distinguishing whether this is from a substance use disorder or is this because it's sort of typical adolescent behavior. Those are, those can sometimes appear like one another, but they're not necessarily the same. So I think that it's an appropriate consideration to take into effect the age of the person that's appearing before you in dealing.
I think it's great to have judges who are taking this into account. I think there's good programs around the state, like the Each Court emerging. So I think there's good things to look into, and I hope as a judge that you'll keep this at the front of your mind, because I think it's something we're going to have to deal with over the course of your tenure on the bench. Thank you for your time.
Councilor Duff.
Thank you. You had mentioned when you were hearing counsel follow about you said someone's conduct and responsibility to take that into account.
I'm sorry, I think what I was saying is look at their conduct and see if
Anybody else speak for me, Joe?
what think this was when we were talking about what conduct they actually, you know, the behavior as the basis of the charge, of how they connect with. Does it really reflect charge, or do we have conduct, was it an overcharge, sort of like? So to look at the actual behavior under the charge, if council understood or knew what that certain case on their Rehabilitation record was about.
Why do you incarcerate? What's the goal?
The public safety.
Do you really believe in rehabilitation?
I do. I'm not sure that I could have done my work as a social worker at a state hospital if I didn't. And it's something I brought with me through all of my prosecuting. I do believe in rehabilitation.
Spent time in prison?
I have. When I was in social work school, my placement was at Southeast Correctional Center down in the Shaw Complex. There was Section 35 men at that time. And so I was there a number of times a week for the semester. Bridgewater State Hospital, at the time I was there, was run by the Department of Correction. And I've also had an opportunity to be in the houses of correction, interviewing potential witnesses on my cases. And I actually one time did go down to Cedar Junction.
So you have been in the past, but do you really think that if somebody is, so you know the conditions in our prison, the food they get is terrible. Pennies a day. They don't have money and they can't team, you know, they can be despondent. Prisons make money on their telephone calls, which should be just frankly illegal. Why there's not a third, taking advantage of incarcerated people. If you're in jail or prison, what would give you hope? Why would you want? What would give you services? Yeah, I'm glad you're perplexed because it's the reality.
I mean,
If you have no hope, why try? Right? Why try? And it's the reason why criminal justice reform is so critically is because we waste millions of dollars, even in this Commonwealth, incarcerating people when we could be putting them into programs to work, building self-esteem, paying taxes. We're paying the newest numbers, and I'm stunned by them. I shared them with Council Apollo in a study. I actually didn't believe it was true, but it is absolutely quantified. $90,000 a year per inmate in the state of Massachusetts. For that amount of money, we could have people in training programs working on mass health, because we're already paying the health care, right? Contributing to society, getting skills, and re-entering. This isn't gonna work for every single person. I'm not an idiot. There are some bad people out there. But most people, I think you would agree, are in prison or jail because of bad judgment or mistake. And a lot of times they did things, well, frankly, they were what we would say kids, right? We can quantify. There is scientific evidence. Some people can say it's not true. When I was 25, I, ran a company or I was the CEO of something. It doesn't matter what you did. The science shows that most young adults, their brains are not fully formed. Especially as Councilman Paulo cited, gentlemen, young men. For some reason, some catch up. People develop on different trains. But you will have an ability that nobody else has, and that is to take away someone's freedom. And so I believe one must truly understand, especially because I don't see that you've ever done any defense work, right? You've only prosecuted people. You've only been, and not, I'm not, yelling at you or anything for that, although I am Italian and Irish, so I get that. But you haven't been on that side. So you're gonna have to become King Solomon and really able to dig deep into that. There's so many challenges and you can't solve them all as a judge. But what I do ask anyone who applies in a sense to that bench, to be a creative thinker and come up with new and different ideas. Because the truth of the matter is, Julie Stone, the truth of the matter, despite what anyone in this building wants to say, most people in this building don't care about addicts, and they don't care about people in prison or jail. Because if they did, we would be funding these programs in ways we're not. I worked with drug addicts. It's one of the reasons I ran for governor's council. I was working with opiate addicts 12 years ago. People didn't believe the stories that I was coming home. I lived in big cities as an adult. The difference between crack and heroin, there used to be a really big difference. This is a different heroin that we have today. It takes you don't take it. We don't have enough. The two areas of chaplaincy I've worked in are hospice and addiction. We don't have enough dying people in the world to make all the OxyContin we make. We just don't. But here's the thing. I really believe that we send people to prison. We teach them how to become criminals because they have no hope. They have no hope because they eat crappy food. And we say, well, sign up for this program. And if you do all these programs, maybe you get parole. It's the hitch. Programs are full. They don't exist. I have about 5 letters in my office at home from prisoners across the state saying, absolutely right, that the parole board just rehashes our crimes. They don't look at what we really truly do. And it's punitive. The whole system is set up to be punitive. It's to make us fail. So what is happening, and I bring this up because you've been very emphatic about something I'm passionate about, that is public safety. We are at the cusp, and I believe actually in public safety crisis right now, because we have not been granting people parole, who indeed should be on parole. So indeed, what they are choosing is to serve out their sentences. What someone does that?
They just enter that into society, maybe not with the support system.
With no support, with no check-in, none. Our parole has been so. I have been a huge friend, and not to be mean, but because public safety is at risk. That's what this is driven by. Because public safety is at risk. When we have men and women coming up for parole here, they get a hearing, they wait 9 months to a year to get a decision. The decision is written by somebody who wasn't even in the hearing. That didn't happen. And instead of the in-depth decisions that we used to do, which were part of the national program that we had finally come to, where we were supposed to be or close to it, we were all out the window. Under this administration, all out the window. They get 3 or 4 paragraphs saying you got tonight, It's no steps. So they can't. So why not just sit here in prison? You know what the rules are. We get fed, it's crap food, but you get fed. You're not going to get a job when you get out anyway. You're not going to be able to get a driver's license. And the biggest thing you're not going to be able to get is What's the hurry to get out? You see what I'm saying? It's real. It's real. If we say, well, we better keep them in there for safety, and we're having the exact perplexing to me that people don't see. Because because you're clearly bright, you've got a good resume, you've done some good work, this guy's a big fan of his. But it really concerns me of really having a holistic view of what this is. And I'm not convinced you have it. I know you have a lot of political connections and you know a lot of people. Everyone here has said I've got calls and this and that. They're raising the eyebrows. Maybe you don't. I don't know. I know you called me once, you left a message and you never called me back. I don't get it. This is a job interview. Maybe my vote doesn't matter. I don't know. But it perplexes me. You know, you are smart and you're capable. But I think you're missing a really big piece of what you need. I'm not going to put you through the steps today in public, but I want you to come and convince me. Because I'm not convinced. Really not. I think you're terrific. I think you are very thoughtful because you've stopped and you've paused and you've thought about these things. But these questions are so. It's a despondent business you're signing up for. You might think you've already been in the trenches and stuff. But our judges today, the standard they're held to in what they have to put up there, not just in the stress of the court, but the change you would see. I'm sure you've already seen some of it in this office. But now it's your decision, like Council Kennedy, saying this. You have to decide. It's up to you. You've got to make a decision. And you know what? Sometimes you're not going to make the right decision. Sometimes you're going to be wrong. And sometimes that person may go out and commit another crime. And it may be a horrific crime. And then the press is going to be on your front doorstep screaming at your husband, doing the nonsense that they're doing right now publicly to other elected officials. And because they don't understand we have the separation of powers, I believe that the judge sees stuff we don't see and makes the decision. I believe in the separation of powers. I don't always agree with it. I can't ascertain why they do what they do sometimes, but I do know they're privy to things that we don't. And that's why we do them, right? Pay me the money in the world to be a judge. It's almost plain God. I think it's a really heavy job and heavy work. I'm really pleased that you and your husband have such a deep, long connection. And I think that's really important because that support, as you said, you have to have it. And you're just gonna grapple with it. Hopefully, I'm wrong. But I've seen in my own district what people have said and done to judges when they didn't like their decision. And the names they call them, and calling for their impeachments and protesting in their houses, and it's undone. To me, it's uncalled for. We just don't behave like that. It's not simple. I spent an entire day years ago in the Superior Court in Salem, speaking to every single employee who had been harassed. By a bunch of crazy nuts screaming outside because they didn't like what a judge did. And then saying the judge was a left-wing move bad and all this stuff, which is ironic, since he's very conservative. Florida judge, and I think he knows what I'm talking about. But it's amazing to me. And I'm an emotional person. But you can't take that out on me. Because despite, this council gets attacked and vilified all the time. My answer to that is several things. One, there's only 8 of us. So when there's a little bit of crazy, you can't absorb it that easily. There's 40 senators, there's 160 people in the House. You can spread it out a little bit more. We can't do that, right? It's right out there. But we have the best system in the country. Massachusetts is the best system in the country. We really do. And it's why we have the best courts and the most aggressive laws. Because of how we do this. We actually have the check and balance in place. We don't elect our judges. We don't let the state senate get involved in it because I don't even want to think about, bless their hearts, I've got many friends in the Senate, but I don't want to think about what the budget can be, and I don't want to think about the pay play. So, they got us. Should we not do that? But I do think you're terribly talented and bright, but I do want to talk to you later this week more about this, and really, you know, what can you do as a judge to give somebody some hope? Can you? You know, different people are gonna here before you. I will quickly go through. I know you've done your homework and you've studied all of us. I care about, because I have a background working in evictions, like everyone, I care about people. Truth be told, if you really want to get people that opiate addicts sober, we're not going to spend money, it's going to cost money. We do have a great program up in Gloucester called the Angel Program. I suggest you study it. It works. It's got a very low recidivism rate. It's been wildly successful, unexpectedly so. Beyond our comprehension. Our police chief, also a very conservative man years ago, came up with it. Because we can't rest our way out of it. The chances of being on heroin and coming off sober for 5 years are about 1%. We've got that. We've got people with different abilities. Mental, physical, sometimes, you know, cognitive. Folks who, say, on the spectrum, Asperger's, or one of the myriad things that falls under that. They appear. But may not behave appropriately, or what we consider appropriate. I think our courts have done a terrific job of training on this issue, but we need to do better. We need to be better at making our courts really accessible to people. Fine. We are just, you know, I have been administration have to listen to me. You know, we're starting to really reach into those communities and saying, hey, will you apply to be a judge? You know, we need people who have those line of experience, and we privilege experience. And then the third category, LGBTQ, every other letter in the alphabet people. It's particularly with the transgender community today. Folks are being taken for it. We have an epidemic in this country and in this state of young people, gay, lesbian, transgender, sexual, living in the streets. We have an epidemic of AIDS in that community. We have an epidemic of pregnancy. Because many people feel safer on the It's our job, like the officials, but as adults. Doesn't matter whether we agree with them, we understand it. It's real. I've got celiac disease. You don't have to understand that, but it's a real thing, right? It's just part of who they are. And so those are things that if you don't have experience, I know again, our courts are doing a great job at the effort to educate. Because the reason why somebody is a sex worker, or sleeping on the street, or stealing, you really have to, you know, it's not just
Like I've been here 2 days.
why are they doing it? You know, what can we do to try to? You're not going to, but I really want you to think. I love crazy big ideas. I love creative. I think it's really our only hope. I will tell one last story since I'm on. One of the most powerful experiences I ever had in my life was on a rotation at Gardner Hospital. And I'd be on a night rotation to see the patients. And a lot of patients really don't want to come in and bother. So I used to go to the NICU and say to the nurses, do you need any help? Yes. Stuff, oh my God, that's going to doctor, we need help. Could you hold some babies for us? Well, I love this. And so I would go in and I would hold babies. But I was holding babies who were going through withdrawal, who were hooked up to all these machines monitoring their heart and their. And the feeling of complete helplessness, and sometimes hopelessness, those babies started screaming because it's beautiful. It's really necessary. But when the alarm started, I couldn't stand the moment. It's literally going through withdrawal. And all the bells and whistles go off. I swear, if you brought a kid in and had to do that, he would really. I don't know that you can do that. I don't know that you can make people do that. But it really that's the type of thought experience. It's like the doctor whose kid wants a motorcycle. They don't know motorcycle. Spend every afternoon for the next, 3 weeks in emergency. You know where I'm going with that. So take that home, chew on it, and we'll talk later. Thank you very much. Thank you, Madam Mr. Chair.
Thank you very much. I'm going to ask you to chair for a few minutes while I just run
You bet.
the door. Council's waiting.
Thank you. Per the custom, called the very last. Anyway,
last minute.
I just want, pardon me? I didn't hear what you said. I want to thank you for the time that you afforded me. That was great. And I remember when we spoke, you said that you called all the counselors. You told me that. And I was very pleased to meet with you because I meet with everyone. And I want to know the whole person, not just someone on the paper. So it was my pleasure, really. So let's go back to your journey here. How many were at the JNC hearing?
10 or 11.
Wow, you hit the jackpot. Only 10 didn't see you. So 10 people voted, never saw you, never talked to you. And that's my objection. I've been here 21 years, and that hasn't happened with past judicial nominating commissions. 21 have been there, and they know who they're voting for. Imagine voting for someone you never saw, a lifetime position. Okay, let that go. That's not your responsibility to get through, and I'm very pleased. I like your age. I like your life experience that you're bringing. That to me is most important. And with that life experience, you're bringing compassion. I don't vote for anyone if they don't have compassion or empathy. And I could identify with some of the things that you were saying, going to school with 3. I started when I was married and I had 4 children, and I was a full-time student. And I took 5 courses each semester for 4 years. And then I went nights for 3 years to get my master's. But the sad thing is, I wanted to teach. And guess what? I couldn't go too far because I had 4 children, couldn't leave them better. And I was young because I had my 4 by the time I was 25. So I'd be interviewed and I get the same thing all the time. You have 4 children. What do you do when you're sick? I couldn't get a teaching job because I was a mother. And that wasn't 100 years ago. And there was others that did. So let that go. So I identify what you went through because it's very hard, but you had to have a partner to help you through. My late husband, he should have got the degrees, not me, because he did it all. So having said that, congratulations on getting through. The other thing is very unusual, no contributions. So for all your political stuff, no contributions, you don't know anyone to give to. So anyway, but I do want to say that I love your background and working with children with autism. That's a wonderful thing, because there's gonna be people before you that have different mental issues that you'll be more, cautious of. So, one of the things, I'm concerned about is, and I shouldn't say I'm not concerned, I was happy about that you published a chapter, and tell me about that, prosecutor's case in chief.
It was an MCLE chapter in a entire sort of treatise on OUI. There was opportunity for defense attorneys to contribute. I was contacted by someone and asked if I would contribute that chapter to CLE treatise on operating in these cases, the prosecutor's case in chief. So just covered sort of from, soup to nuts, from the prosecutor's perspective, what you should be doing when you prosecute offense.
Well, I'm going to be very open with you. I like people with strong criminal background. And domestic violence and murders and rapes, you've had it all. And I hate to see the news, I hate to read the newspapers because it's increasing. And the numbers of children that are missing and being killed by fathers and mothers. And, I don't know what's happened to the society, but it's really sad. And we need people who are strong in the court. I'm going to be very honest with you. I wish you were going to Worcester District Court. If I was appointing you, that's where I'd put you. A month ago, not me, but the council voted for a 40-year-old. And he went to the Worcester Court. He's gone to the Worcester Court. And he had 2 jobs coming out of law school. One, assistant, one of 13 assistant solicitors in a city hall, and the other working in the sheriff's office. Father's the judge. That didn't matter. I would have voted for him if father was a judge, if he was qualified. He is going to the Worcester Court and he has never seen a criminal case. And you and I both know there are many criminal cases in the Worcester Court. I wish you were going there. So having said that, now, tell me about that petition for commitment and the switching sides. That was very unusual. And then you had one lawyer that had one position and the other one had the opposing. So I read, but tell all the people about it.
That was just a memo that I was asked to write to just look into the law behind whether an expert who testified in a trial on behalf of the defendant was ultimately found not guilty by reason of insanity and DRI. Who later came up to be committed. The Commonwealth could then use that same expert in the commitment hearing. So that was just a legal analysis of that that was intended to assist the judge in deciding that issue.
Oh, okay. You had 49% criminal, right? No, I'm sorry, 49% you in the Superior Court, but you didn't apply to the Superior Court.
I did not.
Why?
The district court, it is just a lure to the district court. It's where I began my career. It has the opportunity, I think, to numbers wise, it does the most volume in trial court. And I think it presents the opportunity to impact positively more people. It's also pretty much every case begins in the district court, whether it's ultimately indicted or not. It comes through the district court at some point. And so there's just a breadth of people that you're able to interact with and help hopefully to positively impact them and by extension, the community.
I hear it in my 21 years from judges in the district court. It's the people's court and you're close to the people. And I always bring up the one that says it all the time to me, Judge Pomeroy. always. He loves it. You couldn't get him out of there. And while I have him on the subject, in my 21 years, he is the only nominee, when he was an attorney, got an award from the Animal Rescue League because he has cases against animal abuse. And they surprised him and they had a big night for him, the Animal Rescue League. I always remember that. Animal lover. So I want to talk about, I think it should be noted that what you've been involved in is remarkable, that you have been at periodic training in the district court, judiciary, you relevant legal, ethical, and political issues training, numerous judicial committees, the Supreme Judicial Court Working Group on Substance Use and Mental Health. That marvelous to bring to the court. District Court Education Committee, the District Court Probation Committee, the District Court Committee on Domestic Violence, and it goes on and on. I think that, helps you to be even a better judge. And what I liked about when you said about, the problems in the court and everything, and you said that the judge should explain to the defendant, about the case, what the choices are and everything. And I think that's what's happening today. I think some people that are in prison wouldn't be there if they made a deal or whatever, they didn't understand. So tell me, how would you deal with that to educate? Can I interrupt my own self and say, also, on that line, what about a pro se defendant? How do you proceed with them versus if they had an attorney?
So I've had an opportunity to deal with pro se defendants at my time in the district court. For me, I was always guided by my personal sense of integrity and responsibility in dealing with people who were pro se and explaining to them what was happening, what we were there to discuss with respect to resolving their case. I always tried to be fair. I would listen to them and give them a chance to explain sort of their side of what happened in the particular offense. I would give them the opportunity if it was something where they said, I have documentation that can support this. Can I bring that to you? I give them another date to do that. And if it in fact supported their position, I would dismiss the case. So I feel that I always acted fairly with integrity when I dealt with pro se.
So what's your most rewarding case? Is there one that stands out?
There was one that I prosecuted in the district court that for me was a great example of a judge's ability in the district court to fashion a resolution that really balanced public safety, accountability for offense, and also to address the victim's concerns and give this person an opportunity to have a second chance. And it was one of the most serious charges that you can come up against in the district court, motor vehicle homicide by negligence. There was no allegation of drinking involved in the offense. It was essentially a woman who literally took her eyes off the road. She was a young woman, 25 years old, took her eyes off the road and hit somebody in the road. And when it came time to be resolved, it was very powerful when defense attorney did a good job advocating for his client and a resolution for her, and correctly addressed the widow of the victim. It's very powerful. It gave me a sense that justice was served to all the people in the case.
Well, I would be remiss if I didn't mention, talking about the greatest strength in the court that you're going to. And I have to say this, what you wrote. Working under the leadership of Chief Justice Paul Dolly is as humbling as it is inspiring. Since he took the helm of the District Court Department, he has worked tirelessly and constantly to improve the function of the 62 district courts of the Commonwealth. For example, he has brought his creative efforts to establish legal support and education for the judges and clerks, promoted dialogue and policies around race and ethnic fairness in the court system, advanced increased diversity in the courts, and tackled increasingly challenging substance use disorder and mental health issues confronting the court. The most impressive thing about the ambitious agenda he advances for the District Court Department is his devotion to the goal he set to promote confidence in the integrity of the judicial system. As someone who works daily under Chief Dolly's direction, I have had the privilege to observe his powerful example of the impact that a single judge can have on the administration of justice throughout the Commonwealth. He is universally respected, and like most effective leaders, he brings out the best in people he oversees through the District Court Department. And you say you want to preserve and attempt to improve the strength of this leadership and to work on the front lines as a judge. So, that to me means a lot. And I think, Judge Dolly, thank you for all you've done, because what I want to ask you is, do you believe there's racial discrepancy in the Massachusetts courts? We saw the Harvard study.
I think, yes, you have to acknowledge that it exists, yes.
Right, yeah. So I'm glad to hear that, that the judge is doing that, and you're going to be carrying that on too. The other thing I liked was you don't take stock of the wins and loses like some people and it isn't just winning, it's to serve justice. So, that to me is so important. And I am so glad that, your husband supported you through that education. We got a loan and everything, and I didn't. So it just, that's the hand I was dealt. But anyway, I am so pleased that you applied and that the governor has appointed you. I just think, for the years that you've worked, and again, I like the age. I don't want 40 years old, you know what I mean? And they've never done a pro bono job in their lives, most of them that I see. And you've earned it the old fashioned way. And that's what I like, and that's what I look for. So I'm going to be the last. I'm always the last. So I'm very pleased to see you again, and thank you for all your time. And I look forward to next Wednesday when the vote will come up.
Thank you.
Thank you, Council. Actually, I'm last. I get to ask the question last. But I don't have any for you. Like I said earlier, you have an outstanding resume with a lot of social work. Started to say you wouldn't get your bachelor at Harvard, then went to BC. We won't hold that against you. For your social work degree. And you've done a lot of great things in your life beyond the law. And, I think it's interesting and good that you started this when you had 3 children went to law school, which is a phenomenal task. I can't imagine. I have 3 daughters and went to law school part-time at night, but I think you're gonna be a great judge. If I can count it. I think you're gonna get the votes next week for sure. I'm glad you're gonna have a conversation with Councilor Duff, because I have had the opportunity to talk to you at length, and I got calls, and they weren't political calls. It was people that know you, and judges that know you, not because of politics, but because of what a good professional you've been. So I'm glad to hear that you're gonna have a conversation with her, and good luck next week, and thank you for applying, and thank you for your service to the community. Thank you. Hit the gavel. Boom. Thank you.
Thank you, Counselor Ferrara.
Thank you.
Next week.
So Hurley,
How you doing, Mary?
Valerie.
Did you get any snow out there? She can't hear me.
No, get the mics off.
I think they did get snow.